Section 4, Resolution of Investigating Prosecutor and its review. If the investigating prosecutor finds cause to hold the respondent for trial, he shall prepare the resolution and information. He shall certify under oath the information that he or as shown by the record, an authorized officer has personally examined the complainant and his witnesses, that there is reasonable ground to believe that the crime has been committed, and that the accused is probably guilty thereof, that the accused was informed of the complaint and the evidence committed against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend the dismissal of the complaint. Within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor, or to the ombudsman or his deputy in cases of offenses cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. They shall act on the resolution within 10 days from the receipt thereof, and shall immediately inform the parties of such actions. No complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial city prosecutor or chief state prosecutor or the ombudsman or his deputy, where the investigating prosecutor recommends the dismissal of the complaint, but his recommendation is disapproved by the provincial or city prosecutor or chief prosecutor or the ombudsman or his deputy, on the ground that a probable cause exists. The latter may by himself file an information against the respondent. Or direct another assistant prosecutor or state prosecutor to do so without conducting preliminary investigation. If upon petition by a proper party under such rules as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverses or modifies the resolution of the provincial or city prosecutor or chief state prosecutor. He shall direct the prosecutor concerned either to file the corresponding information without conducting another preliminary investigation, or to dismiss or move for dismissal of the complaint or information with notice to the parties. The same rule shall apply in preliminary investigation conducted by the officers of the Office of the Ombudsman. Section 5. Resolution of investigating judge and its review. Within 10 days after the preliminary investigation, the investigating judge shall transmit the resolution of the case to the provincial or city prosecutor or to the ombudsman or his deputy in case of offenses cognizable by the Sandigan Bayan and the exercise of its original jurisdiction for appropriate action. The resolution shall state the findings of facts and the law supporting his action, together with the record of the case, which shall include A. The warrant. If the arrest is by virtue of warrant. B. The affidavits, counter affidavits, and other supporting evidence of the parties. Pause. Release. D. The transcript of proceedings during the preliminary investigation and E. The order of cancellations of his bail bond. If the resolution is for the dismissal of the complaint within 30 days from receipt of the records, the provincial or city prosecutor or the ombudsman or his deputy, as the case may we shall review the resolution of the investigating judge and the existence of probable cause. The ruling shall expressly and clearly state the facts on the law on which it is based, on the parties shall be furnished with copies thereof. They shall order the release of an accused who is detained if no probable cause is found against him. Section 6. With warrant of arrest may issue. A. By regional trial court. Within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. If he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused has already been arrested pursuant to a warrant issued by the judge who conducted the preliminary investigation, or when the complaint or information was filed pursuant to Section 7 of this rule. In case of doubt of the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint or information. B. By the municipal trial court, when required pursuant to the second paragraph of this section of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court or Municipal Circuit Trial Court, may be conducted by either the judge or the prosecutor. When conducted by the prosecutor, the procedure for the issuance of a warrant of arrest by the judge shall be governed by paragraph A of this section. When the investigation is conducted by the judge himself, he shall follow the procedure provided in Section 3 of this rule. If his findings and recommendations are affirmed by the provincial or city prosecutor or by the ombudsman or his deputy, and the corresponding information is filed, he shall issue a warrant of arrest. However, without waiting for the conclusion of the investigation, the judge may issue a warrant of arrest if he finds after an examination in writing and under oath of the complainant and his witnesses in the form of searching questions and answers that a probable cause exists and there is a necessity of placing the respondent under immediate custody in order not to frustrate the ends of justice. C. When warrant of arrest not necessary. A warrant of arrest shall not issue if the accused is already under the detention pursuant to a warrant issued by the municipal trial court in accordance with paragraph B of this section, or if the complaint or information was filed pursuant to section 7 of this rule, or is for an offense penalized by fine only, the court shall proceed in the exercise of its original jurisdiction.